mini roundtable session or industry insight session. I would like to invite on the stage Nidhi Jagdish Parekh. She's the head legal ESSAR OGDSL. So may we have a big round of applause for her. And our another speaker, Mr. Jain, Arbitrar AIAC. So can we have a big round of applause for him joining on the stage? So over to you, our speakers.
Good afternoon, everyone. Thanks a lot for keeping awake for our session, which is post-lunch and before the coffee break. And I'm hoping you'll enjoy our sessions as we have enjoyed the other sessions. Myself and Ish are going to speak about the technical challenges that we face, or the challenges we face from the technology perspective in arbitrations and for the online dispute resolutions procedures that are used in arbitrations. Now, let's start with Ish telling us the different kind of procedures we have, that we use generally in arbitrations. What are the general platforms you use, or what are the most preferred platforms, or which ones do you think are reliable amongst everyone?
I think before I talk about technologies in relation to arbitration, it's important that we preface that conversation with the fact that IP disputes are not arbitrable in all jurisdictions. And before you start using technological platforms for resolving a lot of IP disputes, you need to ascertain whether the jurisdiction in which you are having the arbitration, or where you're going to enforce the arbitration award, allows you to have these disputes arbitrable. But that's not the only thing. Apart from arbitration, we have other methods of dispute resolution, like mediation and adjudication, or we have negotiations. Obviously, technology can be used in all of those, and depending on which jurisdiction you are in, there are a variety of softwares available, there are a variety of platforms available. Many of the institutes, including AIAC, SIAC, HKIAC, facilitate the hearing or the mediation through technology. So there is no such fixed platforms that are available separately for IP disputes, but in general, technology is very heavily used nowadays, in at least the post-COVID era, in resolving disputes, whether it's through mediation, through negotiation, through arbitration, and these are softwares that we use on daily basis. For example, for video conferences, we have Zoom, we have Google Meet. We see a lot of mediation meetings taking place, arbitration meetings taking place, a lot of negotiations taking place through those softwares of video conferencing. We have online research softwares. Again, we have LexisNexis, we have Westlaw, we have multiple softwares like that, which provide a large amount of database for research. We obviously then have case management softwares. And there are several online dispute management softwares which are available, which either can be employed by your mediator or your arbitrator. There are some institutes, I don't know if they are there in Malaysia or in Singapore, but in India there are a few institutes who have recently cropped up, where they advertise themselves as we are the only online dispute platform that is available. Obviously, then there are basic softwares for electronic signatures, where parties are now signing their mediation agreements electronically, arbitration awards are being signed electronically. These are daily softwares that we are using in and out. So there are no such separate ones, except for probably something that a case management software is designed for an arbitration hearing. There are not many that is separately available for resolving disputes.
Correct. I don't think we have something specific as such, but I think what really is important, as I'm sure Ish and I and all of us on the floor would agree, is that you need a specific framework. For example, I know Zoom, when we were all using it very heavily during COVID times, was considered to be unsafe or something that could easily be, there was no validity, there was no guarantee that the data would stay confidential, etc. How do you think the framework needs to, or which one? Because technology is a very indispensable part of our society. I think it's very important that we have technology, for innovations, etc., for everything. But what happens is that there should be a framework which you would not know without the basic functioning of and the practicality, the problems you face in the practical experience of those. Should there be a framework in the beginning itself, or some ground rules, and then a framework formed on that or developed on that, or how would you suggest that to happen?
Well, IP disputes are very different from ordinary disputes, especially when it involves a lot of technology, a lot of trade secrets, a lot of patented products, a lot of trademark related issues, because it falls on a different benchmark of confidentiality. Obviously, your mediation and arbitration proceeds on the presumption that there is confidentiality. But moment we talk about IP disputes in arbitration or mediation, the level of confidentiality that is required is far, far higher. And sometimes those confidentialities are required to be maintained even inter se between the opposing parties. For example, you may want to rely on a particular document which is from one of the, or probably one of the metadatas of your system. And you don't want all of that to be disclosed to your opponent. The question comes of how do you present this in the digital environment, because you can't physically. I could have just probably shown it to the court and probably redacted it and given a printout, but we know softwares where you can redact the information online, and if you give that copy, you can unredact it. So these issues obviously come up a lot when you talk about IP disputes, but these are things that we need to regulate, and the law is still it's there, but it's not there. For example, if you realize that I don't know how many of you all have the opportunity of looking at the technology policies and laws that are available in the EU or in Malaysia or in Singapore, but all the provisions to show that this is a technology related offense that has been committed. Are you suggesting that just because they were not defined in the regulation earlier, people were not punished for it? I mean, that's not the case. So obviously we have existing laws to deal with such technologies, to deal with technological advancements, because the basis still remains that some things are ethically allowed, some things are legally allowed, and some things are not allowed. So we do have a framework in place which is identical to what we have for all the physical work that we do. But do we require one catered specifically for online dispute resolution? Yes, we do require. But the next question is, can we function without it? Yes, we can function without it till that does not crystallize, because we still don't know where technology is going to head. We still don't know whether if you come out with a policy right now, will it be sufficient? For example, we are now on the brink of a situation where people are discussing artificial intelligence for coming out with outcomes of the cases. We don't know whether there is something that can be brought before the arbitrator, or whether it can be used in a mediation. That this is the most likely outcome based on an AI software. Can you rely upon that? Or can the arbitrator rely upon that? So these are questions which have yet to be answered, and hopefully there will be some policies, some laws which will crystallize in the coming future to deal with the situations. And until then, it's clearly at the discretion of the arbitrators, mediators, or the arbitral institutions which are governing these disputes.
I think I just add to what Ish is saying also, because we have so many challenges. Now, one of them is that if the antivirus, hackers find different ways to get through your system. You may have an antivirus system, but what if there are viruses that they've created to beat those antiviruses, and at that moment your system completely crashed? Or while you're submitting a document online in the ODR procedures and the system crashes. This has actually happened in one of the, this is actually one of my personal experiences also in my arbitration, where cross-examination, we had an arbitration ongoing, and we were absolutely okay with every part of the hearing being online or virtual, but the cross-examination, we were absolutely not agreeable to that being online. Because when you don't know who's behind the camera. You don't know the length of the room, the breadth of the room. Of course, you can have a camera moving around, showing you, all the four corners of the room. But what after the cameras move from that side? Unless you install cameras in every particular angle, which I think would sometimes not be very practical. Having said that, even if you're adding 10 cameras in a room, what if the network goes down? And what if someone is just being able to prompt you the answers from another room? How do you take care of that? So for cross-examination, we were absolutely hell-bent on it being in person, whichever part of the jurisdiction, whichever geography people wanted to keep it in, as far as the parties are mutually agreeable to that. Because I think technology has its own challenges. It's also happened in so many cases that I'm aware of that you can't, you cannot upload a document. There was a case in Australian court, federal court, for filed by Sino-Dragon for setting aside of an order filed for the final, setting aside the final award. And while he was giving his evidences, they had not taken enough measures to ensure that the technology was on par. My question is, I could be testing technology 20 days, every single day before my arbitration procedure starts or the online procedure has to start. But what if on that particular day it crashes? The judge actually passed the order against Sino-Dragon. Had it, and this question and his remarks in the judgment would have the judgment been different if they had taken measures enough to take care of the technological errors that would have occurred? Probably, I guess, yes. But the judge also observed that there were absolutely no whatsoever measures taken by Sino-Dragon to ensure that the technology is on par, it's taken care of, it's working particularly. So the judgment could have been different had the measures been taken. The judgment was different because the judge observed that they weren't. So I guess that really matters. Coming to, what would you think are the advantages and disadvantages of, let's talk it, I think we're going to moderate the session for each other. He's going to talk about advantages and disadvantages, while I'll pick up the other one.
Obviously, there are obviously advantages and disadvantages. One of the things that I specifically ensure during a cross-examination, which is to take place virtually, is whether you have cameras, you don't have cameras. I think the only way to beat that system is, have the counsel, one of the representatives of the counsel from one side remain present in the room where the cross-examination is taking place, where the witness is present, and that's the responsibility of the party that is cross-examining. Simultaneously, you have everybody else virtually present, except for that one person who remains present and makes sure that there is no witness tampering that is going on. So I think that's one way to deal with it. I in fact have one arbitrator before whom we have a hearing, who himself remains virtually present, but tells that everybody else has to remain present in the room. So I don't know how that works, but yeah, I mean that's technology, and that's his preference, that I do not want to leave my chambers, and I do not want to leave my country, and I'm going to sit here and do the arbitrations. you guys can decide where you want to be and how you want to figure this out. So yeah, I mean, these are nuances which which have to be taken care as the matter progresses. And obviously, uh, if I had to cross-examine as a cross-examiner, I would be uncomfortable doing it virtually, because I would always want to feel what the witness has to say, what the expert has to say, and based on his reactions, based on his body language. I would be able to frame the next question that I have in the mind. And you just can't do that virtually, because you just don't get the feel. Sometimes you just have that vibe when you are cross-examining, and that intuition, and that's missing. But coming to the advantages of using technology in online dispute resolution, I think one of the major advantages for an IP dispute is the speed of redressal. I think that's with the arbitration, the speed of redressal, with the mediation, the speed of redressal increases tremendously. The confidentiality is very high. You can ensure a lot of protocols being put in place so that the data is not leaked, or the data is accessible only to a certain extent. All those things can be obviously taken care of. There is then convenience of the parties, which obviously, whether it's an IP dispute or otherwise, is common for all online dispute resolution methods. You don't have to travel. That again saves cost. In fact, in one of these sessions earlier, I think where GK was speaking, the cost was emphasized upon, and I think one of the major things that every party considers is the cost that is incurred during resolution of a dispute, and traveling or hiring outside counsel is adding to the cost. And when you can have your arbitrations or mediations from the convenience of your own hometown, it's more easier for you to minimize the cost that is involved. So I think these are the advantages of online dispute resolution. Obviously, we have corresponding flip sides to it, that whilst your confidentiality is high, at the end of the day you're still relying on technology, and that's breachable. I don't know if you guys have heard of this person called Kevin Metnick. He was one of the most famous social engineers in the 1990s in the US. And he said, and then that's the time when the technology was really advancing at a full speed in the US. And he always, wrote in his books that, no matter how advanced your technology is, there is always going to remain one flaw. And that flaw is going to be the human being sitting behind that technology. So, we can have all the safeties and all the security measures to keep the confidentiality high in an online dispute resolution method. But at the end of the day, there is obviously a risk, because a human element is involved, and data is unfortunately breachable. It's just a matter of time of how long it takes, depending on the system, depending on the money that you are ready to spend. The other disadvantage is digital literacy. I mean, we a lot of times talk about AI being there, and we using online dispute resolution methods, but how many arbitrators or mediators do we have who really understand technology? I mean, we've had arbitrators and mediators who have struggled to understand basic concepts of technology, forget the physical use of it. I understand, you can't change the name on the Zoom. Okay, that's just nuances. But you don't understand a particular technology is far more cruel on the parties, because you don't understand the sensitivity that is involved in how the procedure has to be governed, what protocols are required to be maintained by both parties when you are using a particular technology. Because if he doesn't understand, he can't tell you what to do. So these are the flip sides. I think obviously there are ethical flip sides, but that's for another time, because it's a very long conversation on ethical issues.
I think another one issue that we definitely face is the admissibility challenges that we may have. Now, you see the UN New York Convention recognizes electronic correspondence. It says that all agreements must be in writing, but it does not say anything about electronically executed agreements. At the same time, it acknowledges agreements that are executed based on electronic communication. So there's again some sort of ambiguity to that. Second, I think another point we have is the enforcement, which I think is a very, very critical part. If everything is online, then where are you, unless the governing law clause is, specifically is not ambiguous, you will have challenges as to where will the award be enforced, and this again depends on every industry that we talk about. Like especially, I come from the oil field industry, where it's a boon to have the arbitration. Every agreement of mine has a mediation clause. Then it has an, if mediation fails in the mandatory period of 90 days, which is the Indian timeline, then it must go into arbitration based on one arbitrator depending on the stakes involved, or 3, or it goes mediation or arbitration. So this has saved us so much money, because what happens in the oil field industry is that we have a rig, and people working on the rig are highly skilled individuals who could be staying in extremely different corners of the world, may not be educated, may not have the basic background that you would want. It doesn't matter, I'm just giving you a brief background on who are the skilled people who work on the rig. But I don't want someone from Australia who's working on my rig, which is in Malaysia, while my company is registered in India, filing a case against me in Australia. That just increases my expense, Australia or Malaysia. So I would, arbitration in that sense becomes a big boon, but it has its own set of challenges which needs to be dealt with. And to add to what Ish was also saying, that I think we should have some basic framework in place when we know, before allowing or introducing for companies to come up with any of these, for these ODR procedures. And then on that line, based on the practical difficulties we face, the legal framework can be, formed. But just to go out there without keeping it an open space may not be the best idea, according to me. We must have some sort of limitations, which can, of course, with time be amended, explored, and opened up eventually. That might really help for the ODR procedures also.
I slightly differ on the last aspect, because as I said, long before the laws were invented to justify that hacking is a crime, we already had cases where people who hacked computers were punished and were severely punished. So it's not that in the absence of a legal framework, you really cannot go out and explore online dispute resolution methods, but it is best that if it is done through a mediator or an arbitrator, or through an institution which understands what technology is being used and what are the protocols that are required to be followed for that purpose. For example, I just given a situation where an arbitrator says, I'm sitting in my chambers and I don't care where the hell you are doing the arbitration. If you want to sit in one room, you sit in one room. You want to go elsewhere and do it, not my problem. I'm going to sit virtually. And it's convenient for him, but he doesn't understand the implication of technology. He doesn't understand the impact of the absence of a person sitting in the room. If those protocols were placed, if he understood a lot of these aspects, then things would have been a little more different. So you can go with the online dispute resolution method, but you need to know who's the arbitrator, who's the mediator, or which is the institution which is doing it, because we're still about at least 8-10 years away from having legal framework in that sense.
Besides, I do think that everyone who is strongly, following the ODR process must have some sort of certification of their technology understanding background. You may not need to do a 1-year course or a 1-month course, but even if it's a 5-day basic course, because you'd be surprised how many basic functions a lot of individuals today, even lawyers may not be aware of. I don't think it has anything to do with anyone's ignorance. It's basically a question of practice. If I am not using Acrobat, I'm not going to know about Acrobat. It doesn't mean, and I will not know the development in that field. So if you know the latest, the formats that you have, or for example, for Word or anything, whichever will be required in online dispute resolution, their literacy is extremely important. I was surprised for one of my, this is during the COVID times, I had an international matter where we were, this was an urgent hearing before Justice Gautam Patel in Bombay High Court, very high stake matter, and again, rig-related matter. They were trying to enforce they were trying to file, I'm not going to get into the details of the proceedings, but the judge was so tech savvy, he asked us everything. He said, do not send any hard copy of the documents to me. Email everything. He created 2 special IDs for this. And I was surprised that he knew which document was what. So he probably took a week's time before the hearing date to mark every document as it has to be. He read through all his papers. Plus, he was ready, he was absolutely on board with everything. The moment we'd say, sir, please refer to this document, he would know it. So that's another challenge you would face in online dispute resolution, because imagine everything is going perfect and I have to open a document and send it across to you, and if the document is not uploaded, what do you do about that? Or if you're referring to a document and that cannot be referred to because for whatever reason it's not, there's a malfunction, how do you take care of that? So his literacy really surprised us, and we were really happy about that. And also because the award was in our favor. But but otherwise, I think that kind of certification is very important to know, at least a subject that they are aware of, and also this.
The question, out of probably around 50 judges in that court, how many others have that literacy?
Absolutely. I'm not going to quote a number to that.
So, that's the point that I've been trying to make, that, we need to ensure that when the judges or the arbitrators or the mediators have that kind of literacy, it becomes easier and more efficient to have an online dispute resolution method. You don't require a framework for it, because your arbitrator or mediator or judge knows what is required to be done. The fact that Justice Patel has prepared 2 separate IDs and he's marked the documents, annotated them, used whatever software, whether it's liquid text or Acrobat. He knows what he's doing, but the others may not. You were lucky that you found a judge who was having that digital literacy. But now imagine in that kind of a case being before another judge who didn't have that digital literacy. Then you would have broken your head against the rock. So the same thing is for the online dispute resolution method. If you have an arbitrator or mediator who doesn't understand technology, you can't expect him to do an online dispute resolution system for you. And whether we like it or we don't like it, most of our arbitrators and mediators, whether in England or in Europe or a large part of Asia, is governed by the retired judges, and no matter how much we deny that, that's the basic fact that is going to remain, that they are not somebody who's ready to adapt technology as much as we would like them to adopt. So we need to be careful when we choose our mediators or arbitrators or the arbitration institutes that are going to be running that online dispute resolution
It
case.
becomes conflicting because some judges or arbitrators could be very good at the subject for which I have the arbitration. But if they're not adaptable to technology, then you're stuck, because you really want him on board as your arbitrator. And it's difficult to put them put through them the point that please, be ready with the technology part of it, or get yourself savvy with it. So that's again another challenge we face. You can't talk them down either. You can't tell them go educate yourself. So all these points matter, and I think subject matter matters. Their technological knowledge matters. Their patience matters, because you don't want to spend most of your time on a buffered connection. If you ever see the Sino Dragon case, you will know that the observations that the judge has done were fantastic. Because this was an online case, the evidence was led online, there was interpretation issues. The solicitor, the interpreter was not available in the country where the witness was, so he had to rely on the solicitor to interpret what the witness was talking. Now, how much of that is absolutely accurate is another question, if you're not an official translator or an official interpreter. And all of these, you have small issues like this which would split up. His photograph was visible and he could hear him talk, but he couldn't, there was no, his voice wasn't coming through. So very minuscule issues, but they can really disturb the entire mode or the mood set for the day for the hearing, because everyone is so geared up when there's a hearing. At least when you go to an arbitration room, everyone's all packed up and like ready to rage and ready to fight against each other in a cordial way, of course. But online, you don't even, you're like all ready to speak and you're all ready with your submissions and it's buffering. How do you deal with that? So there's always going to be those kind of issues which need to be dealt with, and unless you have extremely high network, I don't know if that can always work, or you have to be really lucky with that also.
I think what you say is true.
So, how any experiences from anybody over here that we have with regards to any online dispute resolution processes and the challenges that you faced, apart from what we spoke? The floor is open if anybody wants to share.
Just some comments about your topic, and so it's really very vivid, and to my experience it's painful. I think that it's not painful only for lawyers, for arbitrators by themselves, but also for clients as well. There's one of our experience that we faced that we didn't expect. 1 year ago, we faced with the problem of confidentiality. So it's really almost impossible to have 100% confidential meeting online. Yes, there is very always like for some clients, like because we lawyers, we know about this, that it is forbidden to record if you have a confidential meeting. But it's almost impossible to explain this to the client, that do not do this because you will lose. And so that's what we faced as one of, thanks God, not my partner, who is not a lawyer, but the other side, and so their client, they started recording the confidential meeting. So we canceled it, and we had to do it in person, but to make it in Australia. So which means additional costs, etc. So that's why, and it's really hard to solve this problem. But anyway, if clients, lawyers do and behave in a diligent and fair way, it really it saves a lot of money for all sides. So I think that that's all.
I think I had an experience like that with one of my arbitration cases in 2017, where one of the parties during the arbitration proceeding, just the, I think the preliminary meeting or the one after that, that the party wanted to represent itself, so it didn't come with a counsel or a lawyer, because one of the parties was a lawyer herself. So she said, I'm going to represent myself and the other defendants on my own. I said, very well, you're free to do if you want to, but there will not be any procedural leeways given to you. And the first meeting and the second meeting, she started recording the entire of the meeting, and in the third meeting, when I said that I had asked you to do XYZ things, and why have you not done? She said, no, I have a recording of you telling me that I need to do this. I did not consent in that recording. And I said, how can you record a meeting? Whatever is to be recorded is to be recorded by an arbitrator. I have recorded the minutes. If you have a problem with it, you could have told me that the minutes are not correctly recorded, and you should have brought it up at that time. I mean, it's dictated right in front of you. But you are right. I mean, these issues are some things which happen, and you require then somebody to strictly enforce it. And I had to literally hold her in contempt and refer her to the court that this is. I mean, there is no prohibition on recording, but the recording cannot be without the consent. So yeah, I mean, so it's just who your arbitrator is and how he enforces. I mean, if I was, for example, the arbitrator in that particular case, my first task would be to hold that person either in contempt or impose a very hefty cost for doing that act. So it acts as a deterrent that the party does not do it next time, and it also in some way amounts to that person making sure that that person has a minimum amount of digital literacy in that sense to not do this in future, whether in this particular case or in a future case. So that's, but as you said, it's difficult in the beginning, and there are going to be problems, but that's the only way. The only way through is you have to come out of the tunnel on the other side.
Any questions anybody has for us?
Hi, thank you so much for sharing your views on ODR. And I'm cognizant that the topic today surrounds arbitration, and really this is not so much of a question, but really sharing my experience. I think back in practice, we conducted the entire trial in court through online, Microsoft, was it Zoom? I think we just conducted.
Microsoft Teams, you mean?
No, so we conducted on Zoom, not Microsoft Teams. And it actually went pretty well. So we had.
Congratulations.
Sorry?
Congratulations.
We had our client based in Japan, and we had an interpreter sitting with the client in the room. I think one thing we could employ is a supervising solicitor as well, and we had so we had the registrar making sure that there are nobody else in the room. There are different, the cameras are placed at different angles to make sure there are nobody else in the room, and also because maybe procedurally it's a bit different from arbitration, so we can ensure that the clients are fully aware that you are in court, except that you are in a different space. So I think it can be done, but I am also completely aware of the challenges that comes with it as well. But just really purely sharing from my experience, it sometimes can happen. Yeah.
I think the good part was you had a solicitor from the other side, where the witness was sitting and the interpreter was available. But now if you make everything virtual, so I believe what is important for some people to be physically present, if parties agree for online leading of cross-examination also, is that the solicitor be with the party and be with the interpreter if required to be so. Cameras be placed correctly, as you said. However, in this there are cases where, again, there are, people have, I think they had some mirror wall, etc., and the person was on the other side. So people do find ways to prompt if they have to, which is definitely not possible when you're sitting in room. So it has its own set of advantages, disadvantages, and I don't think there are some things that can be controlled, some things that should be controlled, may be controlled, but it really depends on how the parties want to lead it also, because eventually their behavior will also jeopardize and prejudice the arbitrator against them if they behave in the wrong way. So I guess that's a risk you take when you behave in the wrong manner as well.
Correct, and therefore I said, ethical issues in using technology is a whole different
Yes.
chapter altogether.
Yeah, completely agree. Thanks.
Thank you.
Any other questions?
So do we have any questions?
All right.
All right, thank you, Ish. Thank you, Nidhi, for joining in today for the wonderful industry insight session on the technology and ODR and arbitration. Can we have a big round of applause for them?
I will request a group photograph for the speakers and ask Ms. Mitali to present certificates. So first we have Nidhi Parekh. Please give us a big, huge round of applause, guys. Next we have Jain. Come on guys, give us a big round of applause, Jain.